Welcome aboard Rocket Ship, the platform with the most relevant content for competitive examinations. This is Rocket Ship IAS Lab and continuing with our series on answer writing for general studies papers of civil service main examination. We will discuss a question that you might come across in either GS2 or even GS1 of the mains, because the question has nexus with both Indian society as well as jurisprudence, that is lawmaking of India. So it can appear in either GS paper 2 or even paper 1. Let us read out the question carefully. Abuse of laws meant to protect women creates risk of reversing whatever progress that has been made in the journey of gender jurisprudence analyze. Again, the question itself makes a statement that a particular cause will have a certain effect. That is, the abuse of laws meant to protect women would lead to some form of delegitimization. That is what that should strike you as you read this question, that it would lead to some form of reversal of the whatever progress that has been made in you could say women suitable jurisprudence, women suitable laws. We are introducing our answer with a piece of tragic news, that is the tragic death by suicide of the 34-year-old engineer Atul Subhas has drawn attention to perpetrate, that is alleged abuse of laws meant to protect women. The young man was contesting marital dispute with his wife, with whom he shared a young child. He alleged in his suicide letter, that Section 498A of IPC, that is aimed at protecting a married woman from cruelty by her husband and his relatives. This particular section, that is the Section 498A of Indian Penal Code, it was employed to harass his parents or and his brother too. That means Mr. Subhas' parents and brothers. The point is, the men's rights activists rightly point out that Atul Subhas was not an isolated case. That means in many other cases too, the laws meant to protect women are abused to, you could say, harass, or for that matter, extract concession from their husbands, or for that matter, other men who are concerned with the particular cases. Many other men suffer harassment, blackmail, and social opprobrium, that is social disgrace, when gender justice laws are misused as a weapon. When these laws, which are essentially meant to protect women, are weaponized against men, men suffer many consequences. That includes harassment, some form of blackmail also. Sometimes these laws are employed as weapons of blackmail, and social disgrace too. Sorry. Well-meaning commentators also raise the concern that weaponizing women protection laws to settle a score can delegitimize the very laws. Delegitimize means that these very laws would lose some form of legitimacy that they enjoy in the eyes of the wider society. The wider society would start considering these laws to be unjust themselves. So, how abuses delegitimize women protection laws? Taking up these points one by one. First is, the abuses harden patriarchal attitude and set off reaction from men. You can understand it very, very well. If these laws are these laws start being questioned for some form of, you could say, alleged injustice that they are causing, it would mean that the men would react, and probably the men would react vigorously, including their parents and their brothers, etc. And ultimately, these laws would lose legitimacy in the eye of the wider society. Moreover, the patriarchal attitude would harden, because men would think that these laws are made to, you could say, perpetrate injustice against men. Perversely, these laws, abuses of these laws, can lead to harassment of women themselves, including in the marital home, including the mother-in-law, the sisters-in-law, etc. These laws have often been misused to harass the husband's mother or his sister or his sister-in-law. These laws shut the door on reconciliation. If you abuse these laws to harass your in-laws, we would repeat it, if a woman were to abuse these laws to harass her in-laws, it would essentially shut the door on any form of reconciliation with her in-laws. Frivolous cases burden the judicial system, and in that manner they actually lead to denial of justice in genuine cases. Heavy case log of family courts denies quick relief in genuine cases. So ultimately, the law that was meant to ensure justice to women in the first place is actually perversely it is being subverted, and it leads to denial of justice to women in genuine cases too. The abuses also raise the moral question of procedural and natural justice. You can understand very, very well that under India's jurisprudence, under India's judicial system, someone is considered to be innocent till he has been proven guilty. But these laws often take the position that it is mostly the men is to blame. I'm sorry to say that, but these laws are worded in a manner that they take the position that it is mostly the men who are to blame. This is actually against the most of the canons of natural justice as well as procedural. Elaborating on these points, there is real apprehension that abuses of laws aimed at protecting women would paint the process itself as unjust. They would paint the entire women jurisprudence, the laws meant to protect women, as unjust. This might set off reaction and harden the patriarchal attitude. We are not denying even for a second that there is still some patriarchal attitude in the society. And if these very laws were to be abused by women themselves, what it would mean that it would set reaction from men, and in fact their wider family, and in fact this would also harden the patriarchal attitude. Taking up some detailed sections or provisions of the law. Section 498 AIPC, Protection of Women from Domestic Violence Act, that is the DV Act of 2005, etc., may be employed to harass women themselves from a wife's marital family, that is her mother-in-law, or for that matter her sisters-in-law. It is often seen that the husband's mother, sisters-in-law, etc., are made co-accused as a means of coercion. And the perversion here is quite evident that maybe the husband's sister or the husband's sisters-in-law may not be staying in the marital home itself. They may be staying with their in-laws or somewhere else. Still, they are made co-accused in these cases, just as a weapon of coercion. The laws essentially take the position that no reconciliation is possible. This is based on flawed assumptions. Again, the point is, whenever these cases involve domestic dispute, or for that matter marital dispute, domestic disharmony, etc., our first aim should be some form of reconciliation. We would repeat it, our aim should be reconciliation, except for the rare cases when there is apprehension of, for example, bodily harm or violence against the you could say the complainant. Except for those very cases, except for those rare cases when there is, you could say, some chance of the complainant being harmed, we should always aim at reconciliation. But if these laws were to be misused, this would mean that essentially no reconciliation is possible. Frivolous cases can lead to denial of justice in legitimate cases, as the case burden of more than 1.2 million across 850 plus family courts. Try to recall these statistics. These are easier to recall, that there are almost 1.2 million cases in the 850 plus family courts across India, which are leading to some form of, you could say, congestion in the entire judicial system. This slows down the process of granting relief in genuine cases. Similarly, to take one particular example, while the Sexual Harassment at Workplace Act 2013 has noble intentions, it has been used to settle a score, or for that matter block disciplinary proceedings. You can understand very well, women can take recourse of this law, that is the Sexual Harassment at Workplace Act 2013, for her, you could say, selfish or you could say perverted goals. For an example, to use to settle a score, to take revenge on her male colleagues or superiors, or for that matter even block some disciplinary proceedings. In the long run, this would lead to prejudices against women in corporate hierarchy. What the men would react, they would probably take this as the women being troublemakers. I am sorry to say that, but probably that would be men's reaction. That would mean that perversely these laws would lead to, you could say, denial of women's, you could say, well deserved places in the corporate hierarchy, where they are already not as well represented as their proportion in the population. Now, the conclusion we are coming to is that it is a complex situation, that is the case of, you could say, abuses of women protection laws is a complex situation, as penalizing complainant women for supposedly frivolous cases which are extortionary or vengeful would deter more women from availing of the course of women laws. Again, the point is, if you were to prosecute under the law someone for frivolous cases, what it would lead, it would send a message to women that if something were to go wrong, they might be penalized. Essentially, these laws are meant to protect women who are generally, most of the time actually, who are most of the time in a weaker position compared to the men. But if we start penalizing someone even for, you could say, genuine misuse of these very laws, it would send a wrong signal to other women that they should not approach the courts in the first place. They have to bear these abuses at the hands of their men silently. The Honorable Supreme Court, now coming to some of the Supreme Court judgments, the Honorable Supreme Court has strengthened the argument for procedural justice in cases like Satinder Antil versus Union of India 2022, that provides for protection of accused men, that is bail. The Supreme Court has said in Satinder Antil versus Union of India case that even in the cases involving domestic, you could say, disharmony, or for that matter marital disputes, or alleged, you could say, harassment, etc., bail would be a rule and jail would be an exception. We would repeat it. In Satinder Antil versus Union of India 2022, the Supreme Court had pronounced that even in such cases, bail would be a rule and jail would be an exception. That is to ensure procedural justice. Essentially, the point is, essentially the ball is in women's court. They have to introspect actually that the laws that are meant to protect them should not be abused, because that would essentially defeat the entire purpose of these laws. It would delegitimize these very laws in the eyes of the wider society. The laws have to be applied sorry oh, the laws have to be applied sparingly and responsibly if they are not to lose their legitimacy. That the laws should not lose its sting because it is, you could say, alleged that these laws are being abused. That was all on supposed or purported abuse of women protection laws, and the thing is that how they would legitimize, how the abuses would delegitimize these very laws. This is how we sum up our day. We would bring you another lecture in a few days. As usual, we wish you all the best. Thank you.